This is Paul Turner, the immigration barrister at Imperium Chambers, with yet another video on the right to work and the Balagajari litigation. I posted one very recently which listed a number of questions and matters that needed to be clarified as to who had the right to work, who didn't have the right to work, who could apply for the right to work. And so I thought that what would be better, rather than trying to respond individually, would be to try and set out the position in respect of the right to work and the Home Office's position in respect of disposing of the Balagajari cohort of cases. This hopefully will be of some use. Again, if anyone has any specific questions or is interested in anything or wants to know any more, please do not hesitate to get in contact with me and I'll do my best to answer. Now, as we know, in Balagajari, the Secretary, which was a judicial review against decisions to refuse indefinite leave to remain made on the SETO form, that the Secretary of State lost on the basis of procedural fairness, and has undertaken or is proposing to undertake to withdraw the decisions and then reconsider the cases at some point in the future, depending on when the applications were made. Now, as I discussed yesterday, there is a potential discrepancy in the way people are treated, in that people that have a right of appeal, having been refused SETO and then made a SETLR application, are being treated as outside the Balagajari cohort and not granted the right to work. There are other groups, and so I thought what I would do is broadly address all the relevant issues in respect of the individuals concerned and the different types of people and what rights or potential challenges they could make. Now, my understanding is that there are four groups of people, broadly speaking. There might be more, there might not, but my understanding is that there are four groups. The first group is those that have brought a JR, or they've brought an appeal against a refusal of the JR against the Secretary of State's decision to grant them indefinite leave to remain under SETO on the basis that they completed 5 years as a Tier 1 migrant. The second group of people are those people that were refused SETO and then decided, rather than going for a judicial review, perhaps because they've been here for a long period of time, that they would make a SETLR application, which they made, and which was refused again, primarily on the basis of paragraph 3225, which was the basis of the refusal of the SETO applications. And those group have, to a large extent, been granted an in-country statutory right of appeal. The third group are those individuals that have not mounted any challenge at all. Basically, the Secretary of State has refused their application, they haven't made a judicial review, and they haven't lodged any further applications. And the fourth group are individuals that have made a voluntary departure due to financial constraints or family or pressure, or basically just the inconvenience of waiting around for years for this matter to be resolved. So those are the four groups. What is the position in respect of the right to work in respect of those four groups? And I say the theoretical right to work because, as I will discuss at the end, there is a greater, perhaps more pressing issue, which is whether or not individuals actually are able to get a job, given the way that the Secretary of State is issuing letters and only limiting the right to work to some 6 months as per the ECS checking service. Turning to the four groups. The first, and perhaps the easiest to deal with, are those that have the JRs or appeals against refusal of JRs. Now, they form, as it were, the high profile end of the case because they were the individuals directly affected by the Balagajari litigation. And the Home Office position statement is that anyone that writes to Capital House in Liverpool will be given the right to work. That seems fairly cut and dried, though I have seen some refusals or have heard of some refusals, and I would advise that those individuals contact their lawyer, contact me, with a view to challenging such refusals. So they're the easiest group to deal with. The second group, which is perhaps a little bit more troubling, are those that have statutory rights of appeals. Now, these are individuals that have probably, and as I say, I haven't seen all the papers and I don't know all the facts of all the cases, made an application for SETO, it was refused, and then made a valid application within 14 days or 28 days, depending on when it was made, for SETLR. Now, that application, and I've seen a number of them, has been refused on the basis of paragraph 3225. So essentially the Secretary of State is relying on the same basis that the set out application was refused, but afforded them a statutory right of appeal. Those individuals, as I've seen by one letter, the Secretary of State considers not to be in the Balagajari cohort. So he's saying that they don't have the right to be in the United Kingdom, and it's right that their leave had expired, and following various case law, that whilst the application might be valid, being made in 14 or 28 days, their leave's not been extended, and so they're not being afforded the right to work. Now, in my view, that's manifestly unfair, because both refusals are predicated upon paragraph 3225. The only difference being that the individuals, rather than going for judicial review, which has a high threshold to be met to succeed, decided to make a SETLR application based upon their length of residence, and which carries a statutory appeal which arguably has a lower threshold to be met, i.e. that the individuals, all they have to do is establish their case before the tribunal on the balance of probabilities, as opposed to judicial review, which is a much higher threshold. So there is, in my view, in respect of the people with a statutory right of appeal who have been refused under 3225 on 2 occasions, given that the original 3225 refusal doesn't bear scrutiny, ought not be prejudiced by being denied the right to work whilst they proceed with their statutory appeal. If there are such cases, I would advise individuals to contact their lawyers or to contact me with a view to challenging that on the basis that it's manifestly unfair that individuals that went straight to JR can work, but those individuals that sought to make another application but were refused on the same basis are denied the right to work. Turning to the third group of people, which is those people that did nothing, and for whatever reason, whether it was advice, whether it was financial constraints, and whatever. If they haven't made an application, and either for a further extension of leave or a judicial review application, then those individuals are in probably the most precarious position, because they're essentially overstaying in the United Kingdom without any outstanding application, and their attempt to secure a right to work will be exceptionally difficult, because if you haven't challenged the Secretary of State's initial decision or subsequent decisions to refuse you leave to remain, it's hard to see on what basis you qualify for the right to work. Turning to the fourth group of people, now the fourth group of people are those that have made voluntary departures. Now obviously the Secretary of State affording them a right to work would be rather academic, because they're not in the country. And the position as respect to the people that have been forced to leave or made the choice to leave because for whatever reason, that and whether they're allowed back into the country so that they can, as it were, answer the Secretary of State's concerns fully and provide full evidence, is a matter that remains outstanding, or whether they'll be forced to remain outside the United Kingdom and attempt to address the Secretary of State's concerns from abroad. As I say, it's a matter that is still before the courts, and of course I'll update you in respect of that. So those are briefly the 4 categories and what really the consequences are. There is a wider issue, and I'll be participating in a right to work discussion which is being hosted by the Right to Work Limited, who you'll find on my Twitter feed, and who do an excellent job in late September in Birmingham. And I'll be giving a short talk, and I'll be taking questions and hopefully providing helpful answers as to individuals with the right to work. The right to work goes a little bit broader, their organisation, because they don't just cover individuals that have been refused and are pursuing a JR or pursuing an appeal, but also covers individuals with Section 3C leave who've been unfairly dismissed by their employers, and where the Employment Tribunal have maintained the dismissal on the basis that they don't have leave to remain in the United Kingdom, when clearly under Section 3C they do have leave. And there are other issues that we'll be discussing at that event in Birmingham. I'll be posting more details about that event as and when it's finally confirmed, but ideally it should be the end of the month, and it will be in Birmingham, and you'll be given adequate notice. If you can attend, please do. I'll be making a video as to what actually took place after the event. But I would encourage anyone that has any issues in respect of the right to work generally, outside the Balagajari type cases to look up the right to work organisation and engage with them, because they do very valuable and excellent work in raising what is an issue that troubles me and a lot of other practitioners, which is whilst the Secretary of State nominally or lawfully gives the right to work, but does so in a way which is unattractive to employers. So hopefully that's cleared up the questions that people were asking, and hopefully it set out in a fairly simple way what the position is. So in summary, if you've got a JR or you've got an appeal against a JR, you ought to be given the right to work. If you have a statutory appeal based upon based on a refusal under 3225, then arguably you ought to be given the same rights as those that were pursuing the JR, but that's a matter you'll need to discuss with your lawyers, or you can discuss with me. And in respect of those that didn't do anything, then there's not really an awful lot that can be done or argued. And as to those that have left, as I say, their position remains outstanding. If you have any immigration problem, or any member of your family has an immigration problem, please do not hesitate to contact me, Paul Turner, at Imperium Chambers on 0207 242 3488, or Clarks at imperiumchambers.co.uk, or at my site, The Immigration Barrister. Hope this has been of some use and not too boring. I'm sorry to go over the same ground, but this litigation affects a lot of people and is deeply troubling in the way that the government, in my view, has been dealing with it and continues to deal with it. This has been Paul Turner, The Immigration Barrister at Imperium Chambers.